much, Cahir, and I'm sure you don't want this to develop into a broad discussion, but I just want to address briefly a few of the points that have been made. First of all, Minister, in relation to the Insolvency Service of Ireland, and you referenced their annual report, if you look at the statistics that we have so far through the lifetime of the Insolvency Service, there is a problem when it comes to getting proposals approved and over the line. So if you take the figures for personal insolvency arrangements, which is the form that involves secured debt, we have a figure of a yes vote of 51%. That is from Q4 of 2013 to Q3 of 2018. So almost 5 years of data where the yes vote is 51%, the no vote over 39%, and protective certificates expired in the case of about 10%. So the yes vote has not been provided in 49% of cases. And this is following an exhaustive process whereby the PIP, as the independent person who is not acting for the borrower or the lender, looks at the case in full, makes a recommendation, and in half of those cases there's a failure to deliver a yes vote. So that is a point that we have been making. There's an issue there about the veto, which is in place. There is a Section 115A appeal mechanism to the Insolvency Court as such. That's not working. It can take a year or more for cases to come through there, and in the meantime there's immense pressure on the families concerned who are caught up in that situation. I'll talk to you again about that issue, about how in our view it needs to be looked at. But basically, 50% of cases, there's a failure to deliver a yes vote on a proposal which has come from an independent professional who is qualified to deal with that case. In relation to the issue of non-performing loans, there is undoubtedly pressure from Europe, from the single supervisory mechanism and from the agent here in the form of the central bank. It is interesting, though, when I went to Frankfurt with the Finance Committee to meet with the chairperson of the SSM, Danielle Newey, and I said to her, well, it's fine for you to say that you're not advising any individual bank to sell loan portfolios, but you're also telling them that they must reduce their NPL levels to the European average of 4 to 5%. She shot me down straight away. We have not set any target for the banks to reach by way of reducing their NPL levels. And she said that openly to us, but I know what's going on, and I know the pressure is undoubtedly there, but she explicitly told members of the Finance Committee of this Oireachtas that no target has been set for the banks to reduce their level of NPLs to any figure, the European norm or any figure, not to mention advising banks to actually sell loan portfolios. I just thought it was important to put that on the record, because that is what was said, and there were many people in the room who will confirm that. It's also important, I think, to acknowledge that the farm organisations are strongly supporting this legislation. They have come before the Finance Committee. They have explained their frustration at trying to deal with these vulture funds on behalf of farmers to try to get a restructuring agreement over the line. And on the issue of who the contact is going to be with, I think it's worth pointing out that the benefit to the funds currently of appointing a credit servicing firm is that the fund can avoid regulation. They can remain with the status of being an unregulated loan owner. When this legislation becomes law, that will no longer be the case, because the loan owner, the people ultimately making the decisions on the strategy and the portfolio, will require to be regulated. That will involve the imposition of requirements by the central bank. It is an onerous process to become a regulated entity, and the central bank will set certain standards and require certain things to be done to ensure that regulation is fully put in place and vindicated in that respect. I think it is worth acknowledging what Deputy John McGuinness has said as chairperson of the Finance Committee. That committee went to great lengths to get these funds before the committee to answer straightforward questions. I mean, they would have been given a fair hearing, but time and again they have refused point blank to come before us and to be questioned about their business model, about how they treat customers, and about why they wish, of course, to remain unregulated. So thankfully we're at least dealing with that issue, but I think it is important to put that on the record, Cahir, as well.